Welcome back. The next session is entitled Insolvency and Arbitration. Insolvency, or at least financial difficulty, has regrettably been at the forefront of many, if not most, construction companies' agenda globally for the past 2 years. This session is going to discuss the challenges presented by an insolvent party and how to deal with them. For example, can the insolvent party bring an arbitration? How can you secure money from the other party in advance of an award if the other party is in financial difficulty? Is there any point bringing in an arbitration against an insolvent party? What impact has the pandemic had on enforcement, attachment, asset tracing and strategic enforcement? These questions and others will be addressed by a panel, all of whom are experts in this field. Chairing this panel is Claire Packman QC. Claire specialises in construction and engineering disputes and cases involving construction professionals. She has a burgeoning international arbitration practice with an established reputation for arbitrations in the Middle East. She is ranked by Chambers and Partners for International Arbitration and by Legal 500 for construction in the Middle East, and by both for construction and professional negligence generally. As a fluent Spanish speaker, she is also instructed in Spanish or Latin American arbitrations. Her recent cases have been high-value disputes involving the construction of international airports, shopping malls, motorways, solar energy plants, wind farms, government ministries and bridges. Quite the resume, I'm sure you will agree. Claire, over to you.
Good afternoon. We're going to talk to you about insolvency and international arbitration. Our talk is going to give an overview of the sort of things that parties, lawyers and arbitrators need to bear in mind when one of the parties to an arbitration or planned into arbitration becomes insolvent or looks as though it may become insolvent. Our talk is going to be in 4 parts. I'm going to start with a brief introduction to the topic and look at some of the questions that arise and draw your attention, if you're not already aware of it, to a very useful resource to assist with answering those questions. That is the IBA toolkit. Then I'm going to hand over to James Doe, who's going to discuss practical measures that can be taken in a situation where one party is insolvent or in danger of becoming so, including the use of emergency or expedited procedures. James is a partner at Herbert Freehills and the co-global head of the contentious construction practice, with over 20 years experience advising in respect of large construction, engineering and infrastructure disputes. James specialises in international arbitration in respect of oil and gas field development projects, chemical processing facilities, power stations, and major civil infrastructure. As well as working in London, James has lived and worked in both the Middle East and Asia for a number of years, and also has a particular interest in emerging markets, including Russia and Africa. Then we'll hand over to Annabelle Treadgold, who's going to look at attachment, asset tracing, and strategic enforcement, both after the award and how to sensibly preempt these issues by advanced planning. Annabelle's a partner at Jones Day in London. Her practice focuses on multi-jurisdictional litigation and arbitration, with an emphasis on civil fraud, asset recovery and enforcement matters, and disputes arising out of the resources and construction sectors. Annabelle's worked in London, Singapore and in Australia, and recent experience includes advising a global construction company in disputes arising out of the construction of an oil refinery in the Middle East, advising a listed company in relation to a significant fraud involving around 30 jurisdictions, and advising the liquidators of a group of companies in their claims against a former director and shareholder. And then finally, we'll have some time for questions. So, my introduction. What I'm going to start by looking at is the legal implications of insolvency on an existing or planned arbitration. It's probably sensible to start by looking at why insolvency is such a problem in the arbitration field. And that is because it brings a conflict between what the parties have agreed, their agreed dispute resolution process, arbitration, and the statutory insolvency provisions which may be applied by local courts. Arbitration is based on consent and the contractual agreements between the parties. It enables parties to work in jurisdictions where they might otherwise not be prepared to work. But insolvency is a matter governed by national law and may have mandatory provisions based on public policy that cut across the parties' contractual agreements. So typically you find that insolvency regimes tend to try to collate claims so that there is one streamlined process dealing with the insolvent company and bringing all the claims under one umbrella. Whereas in arbitration, the parties want their particular dispute to be resolved by the arbitral body that they have chosen. And this creates a potential clash of jurisdictions. Parties will find themselves in a situation where there are potentially at least 3 different sources of rules to cover the situation they find themselves in. There is firstly the law of where the insolvency is taking place, secondly the law of the seat of the arbitration, and thirdly the law governing the arbitration. This may present a clash of jurisdiction and need careful conflict of law considerations. Let me give you an example which shows quite neatly how that can affect an ongoing arbitration. There was litigation between Electrim and Vivenda, where back in 2001, I think, where arbitrations were proceeding in England and in Switzerland between the parties, when Electrim, who was a Polish company, went into insolvency. Polish law at the time provided that in the case of insolvency, any arbitration agreements were cancelled. The English and Swiss courts took different views as to whether the arbitrations in their jurisdictions could proceed. The English court said yes, the Swiss court said no. The English arbitration proceeded and an award was obtained. On enforcement in Poland, the Polish court in fact allowed enforcement of the English arbitration award. So very different results depending on the jurisdiction and the local law. How does one then navigate these complex issues? Obviously, the problem is that you may have to look at a number of different legal systems in order to determine whether or not a claim can proceed in arbitration. There is a document that has been produced just this year in March 2021 by the IBA, that's the International Bar Association, and it's a toolkit on insolvency and arbitration and has extremely useful guidance. It was conceived with the goal of providing guidance to parties, counsel and arbitrators in situations where a party involved in national or international arbitration is subject to or becomes subject to insolvency proceedings. The chair of the committee that wrote the report was Dr. Manuel Penares of King's College, where we are holding this event. And it is an extremely useful resource, and I recommend it to you. It has a report which discusses the various issues which arise, but most helpfully for practitioners, it has a checklist and answers to those questions for 19 countries. Those countries are Brazil, Chile, China, Colombia, Egypt, England and Wales, France, Germany, Hong Kong, India, Nigeria, Peru, Poland, Russian Federation, Singapore, Spain, Switzerland, the Netherlands, and the United States. Now, the checklist, which is extremely useful, has 30 questions and is divided into categories. I'm not going to read out all of the questions there, but they do provide a very good framework for analysing the situation in which your client is placed and the various different rules which may or may not apply. Category 1 considers conflict of laws considerations, and as I stated above, the starting point is to identify the 3 different laws. If they are different, some may be the same, but the law where the insolvency is taking place, the law of the seat of the arbitration, and the law governing the arbitration, and to consider for each whether they have express rules which affect an arbitration in the case of insolvency and the interaction between them. This will flush out questions of whether proceedings can be commenced or continued against an insolvent party. In some jurisdictions, there will be a stay of arbitration proceedings, or permission may be needed from the administrator or from the court. In practice, arbitrations will often continue regardless of a local stay if the stay happens in a jurisdiction which is different from that of the seat of the arbitration. Category 2 deals with commencement or continuation. Does the national law permit the arbitration to proceed concurrently? The rules may differ depending on whether the arbitration is pending or whether it's commenced, whether it's the claimant or the respondent who's insolvent, whether it's a liquidation or a restructuring process, and whether the insolvency is voluntary or compulsory. So it's important to know in each case which of those categories your particular insolvent party falls within. Category 3 deals with the impact on the arbitration agreement. Does the national law permit termination or suspension of contracts? And if so, in what circumstances? Can the arbitration agreement itself be terminated or cancelled because of the insolvency? We've seen in the example I gave before that used to be the law in Poland, which automatically cancelled the arbitration agreement. Category 4, practical procedural considerations. Who can participate in the arbitration? The parties, the insolvency practitioner. Who can you settle with? Very important to be clear about that and the role that the insolvent party itself is allowed to play. Who is bound by the confidentiality provisions? And then finally, category 5, enforcement. Are there rules governing what creditors need to do, and have they been complied with? Are individual enforcement steps prohibited? And then, most importantly, this is one of the questions, will the arbitration award be issued in sufficient time to be considered in connection with the administration of the insolvent estate? If not, does the arbitration award still provide meaningful redress to the creditor? And it's worth pausing on that, because this question of meaningful redress, is it worth going ahead? It will depend on the facts of the case, but you'll be greatly assisted in trying to understand whether there's meaningful redress by going through that checklist and looking at the ways in which the arbitration will be impacted by the insolvency. And as for further practical considerations, it's worth thinking what steps you can take and when in order to make sure that you can get some meaningful redress. And in that regard, I'm going to hand over now to James Doe.
Thanks, Claire. So if you believe that your counterparty is close to insolvency, you are likely to be concerned that there is insufficient time to commence an arbitration and obtain an award and enforce that award in the normal way before the insolvency procedures commence, and therefore avoid all the problems that Claire's just summarised. So in the context of an arbitration agreement, what options are available to you in order to act swiftly and protect your position as best as possible using those arbitration procedures that the parties have agreed before the insolvency proceedings commence? So what might you want to do? You may want to prevent cash or other assets being transferred outside of the jurisdiction. This is something that can happen immediately prior to an insolvency on international projects. You may want to prevent the calling of performance bonds before the proceeds get lost in a lengthy insolvency process. Similarly, you may want to secure payment of an undisputed but as yet unpaid sum of money, or receive goods or materials, again, before they become embroiled in a lengthy insolvency process. One of the options that you can consider is emergency arbitration, which would provide you with all those remedies, provided the requirements are satisfied. Such interim remedies could be very helpful because they would prevent a person or entity from being able to deal or dispose with those assets pending resolution of the underlying dispute. This would include a liquidator or an administrator appointed after the order was made. Such orders would normally remain in place and bind those parties even in the event of a subsequent insolvency. This is certainly the case in England and Wales. So a little bit about emergency arbitration generally. In normal route to the constitution of a full tribunal statement. For example, under the ICC arbitration rules, prior to the introduction of the emergency tribunal would need to have been fully constituted before it had the power under Article 28 of the rules to grant interim or conservatory measures. As we know, the constitution of tribunals can take a number of months. The challenge for an institution was how to deal with urgent matters arising at short notice and before the tribunal had been constituted, specifically in circumstances where the local courts were not a viable option for whatever reason. It was in part the need to address these types of situations which led the institutions to adopt emergency arbitration provisions. The ICC emergency arbitration procedures were first introduced in the 2012 version of the ICC rules. Specifically, introduced Article 29 that states that a party that needs urgent interim or conservatory measures and cannot wait the constitution of the arbitral tribunal can make an application for such measures pursuant to the ICC emergency arbitrator rules. Now, the key criteria here is urgency. If it is not urgent, the emergency arbitrator does not have jurisdiction to issue any interim or conservatory measures. I should note that other arbitral rules are available and similar processes are also set out in the LCIA, SEAC and HKAIAC rules as well. So how might an emergency arbitration be used in the context of insolvency. In terms of how useful an emergency arbitration could be in the situation of impending insolvency of a counterparty, there's always going to be a reasonable amount of uncertainty about whether they're going to become insolvent or not, usually right up to the last moment. That is certainly my experience. As we all know, there are always rumours in the market about one or other company which is in financial difficulties. Often nothing comes of these rumours. As a result, it may not be easy to persuade an emergency arbitrator that a situation is sufficiently urgent to warrant them awarding interim and conservatory measures. The evidence of impending insolvency simply may not be strong enough to justify those measures. Therefore, the timing of an emergency arbitration application in the context of insolvency will be critical. Making the application before you have strong evidence of impending insolvency, and the emergency arbitrator could well reject your application for lack of urgency. For reasons already discussed, waiting until the insolvency has actually occurred is also likely to defeat the object of this exercise. Some personal experience of mine in this context. I've been fortunate enough, if that's the right way of describing it, to have defended clients in two different emergency arbitrations. Both cases brought by contractors for injunctions to prevent the levy of substantial amounts of liquidated damages. In one case by way of deduction from final milestone payments, the other by way of a call on a performance bond. In both cases, it was argued by the contractor that if the owner was not prevented from levying the liquidated damages by the emergency arbitrator, then there was a significant risk that my clients would be unable to repay those liquidated damages upon the contractor's successful claim for an extension of time. Because it was submitted, my clients were technically insolvent. The central piece of evidence submitted in support of these arguments by the contractors in both cases was that my clients were special purpose vehicle companies that were entirely dependent for income generated from the projects in question. Both were power station projects. And because completion was delayed, there was no income. As a result, it was argued that the SPVs were likely to be forced into insolvency before any arbitral award could be obtained and enforced. In both cases, there was no evidence whatsoever that this was likely to happen, in fact, and the applications were dismissed for different reasons in any event. However, I would say this: one can imagine a different hypothetical situation in which an emergency arbitrator could be persuaded that an interim injunction was appropriate, but only if there was convincing evidence that the owner was insolvent or otherwise on the brink of collapse. As I've already mentioned, that may be quite difficult to obtain. I've already mentioned the need to establish urgency, but what other limitations and risks are there in using emergency arbitration in the context of an insolvency? The first is that you will need to provide an advance on costs, probably in full. The other party is unlikely to be paying anything. That's also true of the cost of the entire proceedings, whatever the outcome of they may be. And of course, we have the risk of struggling to enforce the award, something which Annabelle will be discussing in a moment. The counterparty will also have a shortage of funds, so it is unlikely to comply with any of the requirements that may be forthcoming from the emergency arbitration in any event. Another risk could arise from the need to provide an undertaking in damages to cover the losses suffered by the counterparty in the event that you turn out to be wrong about the substantive issue. Those losses could be extremely large. One final point. Is there any benefit in using the courts over and above an emergency arbitration? Well, depending on the jurisdiction in question, you may have no choice but to use emergency arbitration. For example, in the well-known case of General Metals, the English court held that there was insufficient time, where there is insufficient time for an applicant to make a claim for relief from an expedited tribunal or an emergency arbitrator, the court does not have the power to grant interim relief. In particular, section 44.5 of the Arbitration Act provides that the court can only act if an arbitral institution has no power or is unable for the time being to act effectively. A situation in which emergency arbitration would certainly not be useful and a court would be the most appropriate venue is if the application you want to make needs to be made ex parte, such as a freezing injunction. Other considerations might also come into play. The need for confidentiality. Obviously, this would favour emergency arbitration. the legal test to be applied. This may be different depending on the decision maker, whether it's a court or an arbitral tribunal. A court is likely to be required to follow strict legal guidelines or rules, whereas an arbitral tribunal may have more discretion. The need to abide third parties. I have in mind, for example, the calling on a performance bond or injuncting the call on a performance bond. You may want that injunction to bind third parties or involve third parties. That's not something that can be achieved through an emergency arbitration. But perhaps the most important question is enforcement. There remains some uncertainty about whether interim measures issued by a tribunal or an emergency arbitrator are actually enforceable under the New York Convention. To this date, this point has not been tested in the English courts, as far as I'm aware. I am aware of a Singaporean case where some guidance was provided by the Singaporean courts, but I think it's fair to say that this issue of enforcement remains uncertain. And on that note, I'll pass over to Annabelle to discuss the enforcement of arbitration awards in the context of insolvency more generally.
Thanks, James. When we talk about enforcement of arbitral awards, often we're talking about the advantage that arbitration is seen to bring over litigation, in that you have this comprehensive framework that the New York Convention offers us for this enforcement. But arbitration awards aren't self-executing. If the award debtor doesn't voluntarily pay the award, you're going to find yourself needing to pursue enforcement actions in local courts. So the judgment creditor is going to need to avail itself of local measures, things where we end up like charging orders, orders for sale, in order to recover the amount that it's actually been awarded. Given that we're in the local courts and given the scale of the countries I understand we have joining us today, whilst there are undoubtedly points of crossover between these jurisdictions, there simply isn't a standard approach to enforcement. So the first takeaway is local counsel advice is going to be invaluable. There's also what we're seeing as anecdotal evidence. You see headlines in things like the Global Arbitration Review week in, week out, of awards being challenged either at the recognition phase or judgment creditors needing to take other action. It was against that background that Global Arbitration Review actually published their text in 2019 and again earlier this year on a guide to challenging and enforcing awards. We're also seeing this ever-present risk of construction insolvency, and I appreciate that's been touched on a few times today. Against that backdrop of COVID-19, what we've been talking about is when that will come, and are we going to see this wave of insolvencies coming down the line? So that's what we're really looking at, is that there is this constant risk in the background that even if we take the pandemic out of it, there is always the risk of insolvency. Arbitration can run for several years until you have a final award that you're actually going to be able to enforce. So the next key takeaway I want to flag is that enforcement due diligence is a risk management tool. This is something you need to be looking at the start of your contractual drafting and not just when you have the award presented to you by the tribunal. So in terms of asset recovery, how do we go about actually executing an asset recovery strategy? Broadly speaking, I'd split it into three phases. We have the initial information gathering. We then move into preservation of assets and then trying to enforce against those assets. Often this is a coordinated approach across multiple jurisdictions, and we need to continually update that strategy according to developments. If we find out about further assets, we're going to be looking into different jurisdictions. Often this is a different legal team to those who have conducted the arbitration, but if you have any points of crossover, obviously that's going to be incredibly helpful. In terms of practicalities of information gathering, people often ask, well, what is it? How do you find it out? Often we're actually just in publicly accessible resources like corporate filings, land registry documents. Some jurisdictions have beneficial ownership registers. This might be done by the lawyers, or you might bring in a private investigations team to do a full-scale inquiry, whether by desktop or actually on the ground. They're looking for anything: shares, real property, often machinery, equipment. What is there going to be at the end of the day that we can enforce against? Some jurisdictions also have provisions for getting orders against that judgment debtor if you have the award, or against third parties, compelling them to provide you with such information. Taking it very broadly, common law jurisdictions are usually more amenable to that, as opposed to civil law jurisdictions where it's harder to get that level of information, particularly in support of civil proceedings. Once we have that sort of database of information, we're looking at what preservation measures may actually be available for our clients. And the next takeaway I want is that this doesn't actually give you a preferential right of security. If you get this ability to seize the asset, it preserves it for you until you're taking those steps to enforce judgment. It doesn't actually move you up the line, but of course it can completely shift the dynamic of the proceedings moving forward. you might find that the formal process of enforcement isn't actually required because you've got that pool of assets sitting there at the end of the day, and so you're effectively fighting from a stronger position. James mentioned there can be a discussion about, are you going to go, if you have an arbitration on foot, to the tribunal, or are you going to go to the local court systems? Again, it's going to be case specific, and tribunals are empowered to grant these interim or conservatory measures. There's things that are floated like security of costs, or in fact security of the claim. Those orders can often be seen as difficult to obtain, and the issue with tribunals is often put that they don't have coercive powers to enforce. So you can't take that order and enforce it against a party and hold them in contempt of court, and their orders can't bind third parties. Practically, having such an order like that, and if the party in an existing arbitration goes against it, it's obviously not going to put them in a great light in front of the tribunal if they take active steps to ignore an order of that tribunal. But you might find yourself saying, well, I'd rather end up in the court system given they have these coercive powers to support arbitrations or post-award enforcement. There's many different orders available, but two of the ones that are often floated are attachment orders. Often these are specific assets are identified, and we get very specific orders in those jurisdictions by the local court where the asset is, attaching that asset. Sometimes those can be very narrow and they're not going to bring in your worldwide assets. So what you might be looking at is a freezing order and potentially a worldwide freezing order. But the real teeth of those orders is often in the ancillary disclosure provisions. And what you're trying to seek is further information from that potential judgment debtor to tell you where are the rest of their assets around the world and how can I think about securing them. These orders are incredibly draconian. They're often ex parte, as James mentioned, and they're going to require you to put on real evidence of a risk of dissipation. So what evidence do you have that judgment debtor is moving assets? We're looking at things like opaque corporate structures, unexplained movements in balance sheets, what's going on that can't just simply be explained away. If your judgment debtor has in fact gone into insolvency, as Claire's mentioned, this is going to affect the strategy because most insolvency laws are going to prohibit enforcement of awards outside of those insolvency proceedings. As Claire said, what the insolvency is seeking to do is effectively pool all of the creditor claims. So unless you can prove a proprietary right or you've got security over a particular asset, your claim is going to rank equally with the other unsecured creditors, and you're going to find yourself having your claim determined in the insolvency. There's going to be numerous issues to work through. Things like Claire said is the insolvency in the same jurisdiction? Is it a foreign insolvency? Has that foreign insolvency practitioner taken steps to recognise their proceedings in your jurisdiction where the assets are? Are you even going to be able to take any further steps? Because keep in mind you're commencing further civil proceedings in order to enforce against those assets. Will it be pointless to do this? Are you going to end up brought back into the insolvency in any event? There could be merit in doing it. It could help substantiate your proof and you might get permission to do so. But the other factor to keep in mind is it might be worth considering, is this something that you should be looking at settling sooner? Is that actually going to get your client the best outcome, given they may end up with not many pence in the pound in an insolvency? Just to sort of wrap up before I think we might move on to some questions, is there's a recent and ongoing set of cases, the ArcelorMittal and Essar Steel cases, which brings together many of these issues, and some very high-level points coming out of that because there's a comprehensive enforcement strategy that you can see being deployed worldwide in that case. But fundamentally, it's a $1.3 billion ICC award from December 2017. It was a termination of contract for the supply of steel. The award recognition was sought for it around the world. I think it was Minnesota, Mauritius, England, and the Cayman Islands. There was a challenge to the recognition in Mauritius on public policy grounds because there'd been an initial bankruptcy, confusion as to where the documents were, and Essar Steel said, well, I'm not going to engage in this arbitration, and they didn't participate in the hearings. They then sought to argue that there was a lack of due process. That judgment came down just a few months ago in July, and the due process allegations were dismissed, but gives you a flavour of the sorts of things that will be coming up in these kind of cases. Enforcement is happening around the world. There's a worldwide freezing order in England. There was voluntary administration then filed for Mauritius. There were disclosure orders in the Cayman Islands. Just last month, they filed further proceedings in the Southern District of New York, seeking the unwinding of allegedly fraudulent transfers. So this effectively is they're running a case on the basis that the judgment debtor is deliberately seeking to drain its assets around the world. And this is the sort of activity that we may be seeing on the rise, this sort of commentary that's coming down, that we might be seeing parties taking more interest in interim preservation measures, looking to secure their assets sooner in order to best preserve their position. And also we might see a rise in unsatisfied arbitral awards. And this is certainly the sort of headlines that we keep seeing come across our desk seems to indicate that's the way we're headed. Claire? James?
Over to James to tell us if there are any questions, I think.
Thank you very much. There are some questions as it happens. Thanks to you all for that. The first question is an online question. Again, I'm looking hopefully into the in-person delegation for hands appearing, but hopefully they'll come in a second. The first question is from Isa Dookie from Trinidad and Tobago. In my country, there are a number of state-owned limited liability companies that perform the role of project manager for government construction projects. Construction contracts are made between the state-owned enterprise and the contractor. The government is not a party. The state-owned company usually does not have any assets of its own, but funds are dispersed to the company by the government on a per project basis as needed. Many contractors now find themselves in the position of having done works for these companies and are left unpaid. They have obtained judgments against these companies, but the companies have no assets to levy on and no monies in their accounts. What does the panel think can be done? A very interesting question. I think probably applies outside just Trinidad and Tobago.
In terms of that, I think this is coming up more in the conversation around the ability to enforce against states. And that is sort of a different area that often comes up in investor-state arbitration, but effectively off the cuff, you'd be thinking of looking at things like, have you got an alter ego type argument to be running what's actually sitting behind? It might even be something at the start of the day to see what sort of security you can be getting or certain, what ability you have to actually go against the government. You're going to be then looking at issues of sovereign immunity. So it's not an easy question to answer, but I suppose going right back to the beginning, you'd be thinking, can I get a pool of assets or some sort of security by way of the contract to enforce against any sort of equipment guarantee and things like that would be my response. But we certainly seem to be seeing a rise in issues with defaulting states, but I appreciate here we're talking about a state-owned enterprise.
Anonymous question here. Is insolvency being abused by parties attempting to skirt liability, and how do we pierce the corporate veil for such firms seeking to cover to avoid being investigated?
I'll probably take the first part of that question. I think there's always a suspicion that it might be being used as a way of avoiding liability, but I'm not always sure that that suspicion is made out. I think it's more, it certainly happens. It hasn't happened very often in my experience in cases that I've worked on, but it certainly happens. So I would say it's a concern, but it's not perhaps as used as much as you'd think. I think mostly because certainly with larger construction projects, the market is actually quite small, both on the employer side and the contractor side, and doing things like that just will damage your reputation beyond repair. So my observation is it happens from time to time. It's unfortunate, but it's not as common as you think.
Very good. You have one of the parties is English, the other party is French, project is in Spain, law of the contract is Swiss, and the seat of the arbitration is Singapore. Which insolvency rules will apply in that scenario?
I think that's an example of a detailed question which involves looking at the various competing rules. But you've got some very different legal processes there. You've got 2 EU countries in there. You've got England and Switzerland and Singapore, which are not. You're going to have to go through that to unpick it piece by piece. And I'm afraid I don't think it's an answer for now.
Yeah, very fair enough. Okay, final question from Calvin Callum. Thank you to the speakers for a very enlightening comments on arbitration and insolvency. Could you please elaborate on the interim preservation measures contractors may use in order to safeguard themselves from later insolvency?
terms of security of liens over property and the like.
And yeah, I mean, I guess that's exactly right. I mean, whatever you can put in your contract to, and it's important that it goes in your contract, I think, to give you the best possible chance of exercising those rights, is to make sure that if you have concerns, that you put them in your contract. You know, contractual liens, certainly enforceable in the UK, and I'm sure elsewhere. And then you're not necessarily beholden to the local law in whatever jurisdiction the assets may be located in. I mean, you are to a certain extent, but at least you have a contractual right, and certainly can enforce that right in an arbitration to certain rights over assets and property and materials, equipment, whatever it might be. So that would be my starting point.
Very good. We are out of time. Please, can you all put your hands together for Claire, James and Annabelle? Thank you very much.